Can judges use AI? What are the Canadian courts saying in 2026? And today is day 11. Well, we're going to be talking about lawyers and judges. Actually, today, judges and AI. While lawyers get most of the AI and law headlines, there's a quieter question which is worth asking. Are judges using AI too? And what are the Canadian courts actually saying about it might actually surprise you. In September 2024, the Canadian Judicial Council issued its guidelines for the use of artificial intelligence in Canadian courts. The core message is direct, and I'm going to read it. How exactly is it put? Judges must therefore maintain exclusive responsibility for their decisions. AI cannot replace or be delegated judicial decision making. Whatever role AI plays, the actual judgment, weighing evidence, applying law, deciding outcomes stays entirely human. Beyond that core principle, the guidelines promote judicial independence and safety ethics, safety, transparency, monitoring, and continuing education around all AI tools. They also acknowledge something practical. Some AI is already quietly embedded in day-to-day judicial work when it comes to administration, like translation, grammar checking tools, and all of that. But using AI to make decisions, well, that is something to think about. Separately from how judges are using AI internally in courts, have been issuing practice directions aimed at lawyers and litigants. The Ontario Superior Court of Justice rolled out a new AI practice direction for family and civil proceedings in late 2025, with criminal proceedings following after. These require things like hyperlinking every cited authority to its public source, such as CanLII, and carry a clear message that the court will not tolerate inadvertence when AI generated error slips into filings. Other courts, including the federal courts and the courts in Manitoba, the Yukon, and Nova Scotia, are now require written disclosure when AI is used to help prepare a filing. There is no single rule yet where generally applies to other courts. In Coe versus Lee, a 2025 Ontario Superior Court case, a lawyer was ordered to attend a contempt of court hearing after citing non-existent cases in written submissions. Two real recent Canadian cases, not hypotheticals. And yes, in a video 2 days before, we even spoke about a recent case where a lawyer has been suspended for the next 6 months. If you are litigating, check the local practice direction on AI. It needs to become an automatic checking thing, which we do before a filing deadline. Some courts want a disclosure statement, others want a hyperlinked sources. So you have to check what province you're in and what you're dealing with, just to avoid any contempt cases or anything which you have misquoted or anything. The judiciary is engaging with AI carefully and deliberately, and the courts are already showing real consequences for lawyers who are not taking care of their of rechecking anything they are getting from any AI chatbots. My honest answer is to be very careful while using AI. Yes, it definitely reduces a lot of time as a lawyer, but coming back to the fact that verified sources are very important. Be careful of your decisions as lawyers, consultants, or anybody out there who is using AI professionally. And do subscribe to the channel and stay tuned for tomorrow.